Hi, Attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. Today I'm going to talk about a recurring issue in the proof of alcohol-based DUI cases in California. The difference between Vehicle Code Section 23152A and Vehicle Code Section 23152B. Whenever somebody is arrested on suspicion of an alcohol-based DUI, their paperwork may state both of these statutes. And it can become kind of confusing, especially if you've never been arrested before. What does this actually mean? I was just arrested once. Am I being charged with two different offenses? It seems to not make any sense to people on first glance. And on top of that, the way these statutes work sometimes challenges a lot of deeply held beliefs that some people have about DUI. For example, some people say, well, I wasn't impaired. I'm capable of driving home safe. I would have driven home safe if only they left me alone. So I didn't feel impaired, I didn't feel buzzed. I've driven with this amount of alcohol plenty of times in my life, and my field sobriety tests look perfectly fine. So even though my test results show that I'm above 0.08, why should this be a DUI? On the other hand, some people often think, well, you know, I'm below 0.08, so how can this be a DUI? It's not possible. The way these two statutes work hand in hand shows how both of those situations, unfortunately, can create a winnable DUI case for the government. But if you pay proper attention to the elements of each offense, you can definitely see how these charges can be scrutinized and beat. So let's start with the basics. California Vehicle Code Section 23152 subsection A is the idea of driving under the influence of alcohol when you're impaired, meaning you've consumed an alcoholic beverage, it's in your body, and it is affecting your ability to safely drive a motor vehicle. By contrast, California Vehicle Code Section 23152 subsection B states that you're guilty of a DUI if the government can prove beyond a reasonable doubt that you were 0.08 or more at the time of driving. Now notice, under subsection A, there's no reference to BAC. In subsection B, it's totally based on a BAC, but there's no reference to whether or not you were too impaired. Subsection A does state that if the government can prove you're over 0.08, it creates a rebuttable presumption that you are too impaired. So obviously the BAC count is something a jury can consider when deciding whether you're too impaired to drive. But the government doesn't have to prove you're above 0.08 in order to prove that. Conceivably, you could imagine a situation where somebody is, a 0.05 or 0.06. That is a type of case where, in many counties I practice, the DA's office may decide to pass on the case and not charge it. However, with enough evidence of poor or unsafe driving, or enough evidence of, poor performance on field sobriety tests, the government could conceivably prove, hey, maybe we don't have a 0.08 here, but this defendant was clearly affected by the drink, and the drink clearly affected their ability to drive safely, and they're clearly not driving safely, as we can show in the video or based on eyewitness testimony or so forth, even though if we can't prove they're a 0.08. Contrarily, getting back to Vehicle Code Section 23152B, that could be a case where maybe no bad driving is even observed. Maybe my client is stopped or just having expired registration, okay? But if the government can prove that you were 0.08 or more at the time of driving, even if you can tolerate that really well, that's going to be a guilty verdict of a DUI. So the takeaway here is that when you're fighting a DUI, you have to be really careful about the elements of those offenses. And the evidence that comes in, whether it's testimony about field sobriety tests, testimony about driving patterns, testimony about breath or blood tests, you have to have a proper understanding about where all this fits into how the government is going to prove this case. And with an alcohol DUI, the government might not have not one, but two ways to potentially win. You and your attorney should scrutinize this issue carefully and prepare for these theories when you're going into battle on a DUI case, or at least an alcohol-based DUI case in California. The differences between the two statutes are important, and with good representation, you'll probably understand them better and know the strengths and weaknesses of your DUI case and what the right move should be when you go into court. Thanks a lot for watching. Stay safe out there.